On Wednesday, the Supreme Court of India requested the central government to provide information on the number of first information reports and charge sheets filed against men who have pronounced instant triple talaq, thereby violating the Muslim Women Protection of Rights on Marriage Act 2019. A bench consisting of Chief Justice Sanjiv, Khanna and Justice Sanjay, Kumar is reviewing 12 petitions that challenge the constitutionality of this law. The court has also instructed the central government and other involved parties to submit their written arguments regarding these petitions. The bench has scheduled the final hearing of these petitions for the week starting March 17. The lead petitioner in this case is the Samastha Kerala Jamiathul Ulema, a Muslim organization based in Kozhikode. The court's directive specifies that the central government should provide the total number of FIRs and charge sheets pending under Sections 3 and 4 of the Muslim Women Protection of Rights on Marriage Act 2019. These sections pertain to the prohibition of instant triple talaq and the penalties associated with it. Instant triple talaq, also known as talaq-e-biddat, is a practice where a Muslim man can divorce his wife by pronouncing talaq 3 times in quick succession. Under the 2019 law, this practice has been declared illegal and void, and a husband who engages in it can face a jail term of up to 3 years. In a landmark verdict on August 22, 2017, the Supreme Court had declared the practice of instant triple talaq unconstitutional, stating that it was against the basic tenets of the Quran and violated Shariat.